Good morning. The Judiciary Committee will come to order. Without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I now call up H.R. 2329 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
To ensure appropriate judicial review of federal government actions by amending the prohibition on the exercise of jurisdiction by the United States Court of Federal Claims of certain claims pending in other courts.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. I want to thank Representatives DeSantis and Cicilline for introducing this important legislation to amend Section 1500 of Title 28. I'd also like to thank Senators Wicker, Leahy, Cornyn, and Tester for introducing companion legislation in the Senate. In his first annual message to Congress, Abraham Lincoln admonished that it is as much the duty of government to render prompt justice against itself in favor of citizens as it is to administer the same between private individuals. This legislation responds to that duty. It does so by removing unnecessary procedural obstacles that Congress has placed in the way of the ability of Americans to receive redress from actions taken by the federal government that infringe upon their constitutional, statutory, or contractual rights. H.R. 5683 will clear the path to justice for a wide variety of claimants with many different kinds of claims, including federal employees, members of the military, property owners, businesses, local governments, and Indian tribes. H.R. 5683 does this by amending 28 U.S.C. Section 1500, one of several statutes that govern the jurisdiction of the United States Court of Claims, a federal court that adjudicates cases seeking monetary relief from the United States for actions taken by the federal government. Section 1500 is an antiquated statute that was first enacted by Congress in the aftermath of the Civil War to address a problem that no longer exists. As Justice Sotomayor has noted, judges and commentators have long called for congressional attention to this statute. In many cases, Section 1500 forces plaintiffs to pick and choose between remedies that would otherwise be available to them in litigation against the United States. This is because, under the complex jurisdictional scheme Congress created for lawsuits against the federal government, plaintiffs may be barred from pursuing all of their legal claims against the United States in a single lawsuit before a single federal court. For example, if the federal government released water from a dam flooding private property, the property owner may be the victim of a common law tort for which suit may be brought in federal district court. Or alternatively, the property owner may be the victim of a taking for which suit must be brought in a federal claims court. This jurisdictional scheme would be understandable. Different federal courts have different specialties and expertise. But for the fact that Section 1500 precludes a plaintiff from maintaining lawsuits against the United States arising out of the same incident in both the federal court, the Court of Federal Claims and district courts simultaneously, even if the lawsuits seek different relief. Instead, Section 1500 forces plaintiffs either to file suit in federal claims court foregoing relief in district court, or to file in district court and risk the statute of limitations expiring before the district court litigation is over, leaving them unable to file in the federal court of claims. In short, Section 1500 creates a catch-22 that makes plaintiffs pick and choose between meritorious claims against the federal government. This is not good policy in a democratic society. As the Federal Circuit Court of Appeals has observed, because this nation relies in significant degree on litigation to control the excesses to which government may from time to time be prone, it would not be sound policy to force plaintiffs to forego monetary claims in order to challenge the validity of government action, or to preclude challenges to the validity of government action in order to protect a constitutional claim for compensation. Although Section 1500 was designed to prevent the United States from being forced to engage in duplicative litigation, there are much less drastic ways to avoid this concern. H.R. 5683, through the use of a presumptive stay, provides a method that both prevents the federal government from facing duplicative litigation and preserves plaintiffs' rights to seek complete redress against the government. A legislative fix to Section 1500 is long overdue, and I urge my colleagues to support this legislation. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, I'm pleased to speak in support of H.R. 2329, the Ensuring Access to Justice for Claims Against the United States Act. There are several reasons why I support the measure, because basically it addresses a long-standing flaw in current government. The Court of Federal Claims has exclusive jurisdiction over certain claims against the United States, such as contract claims. Other types of claims against the United States, tort claims, cannot be heard by the Court of Federal Claims and must therefore be determined by another court. Thus, a plaintiff seeking complete relief is sometimes forced to file actions in both the Court of Federal Claims and another court, such as the Federal District Court, even though the actions are based on substantially the same facts. Nevertheless, Section 1500 of Title 28 of the United States Code bars complete relief for a plaintiff if he or she filed suit in another court before filing suit in the federal court of the Court of Federal Claims, if both suits are based on the same operative facts. While many federal courts tried to ameliorate the harsh consequences of Section 1500 by allowing the Court of Federal Claims to retain jurisdiction if the relief sought by the plaintiff in the other court was different from the relief requested from the Court of Federal Claims, the Supreme Court foreclosed this workaround in 2011. In sum, the court held that Section 1500's plain language required dismissal of the Court of Federal Claims action if the plaintiff had an earlier filed action pending in another court based on the same operative facts, regardless of the difference in relief being sought. As a result of the court's decision, Section 1500 forecloses meritorious claims against the United States by prohibiting the Court of Federal Claims from hearing an action against the United States if the plaintiff has pending in another federal court a claim against the federal government arising from substantively the same operative facts. In lieu of dismissal as required by Section 1500, H.R. 2329 would impose a temporary stay on the later filed action until the first action is no longer pending, subject to certain exceptions. Another reason I support H.R. 2329 is that it will ensure access to justice for plaintiffs, particularly those who lack the resources to recognize and avoid a procedural trap embedded in the current Section 1500. Although Section 1500's jurisdictional bar was intended to prevent duplicative lawsuits, it can effectively deny access to justice, especially in instances where a plaintiff makes the unfortunate choice of filing suit in the Court of Federal Claims after filing suit in another federal court. In response to this problem, the Administrative Conference of the United States, a nonpartisan body of administrative law experts, issued a recommendation ensuring access to a complete judicial remedy. This recommendation, in turn, was adopted by the American Bar Association last year, and it forms much, if not most, of the substance of H.R. 2329. Finally, the version of the bill that we are considering today reflects constructive comments that the Department of Justice provided to the Judiciary Committee when similar legislation was considered by the committee in the last Congress. In sum, the Justice Department was concerned that the prior legislation's interest of justice exception to the presumptive stay did not adequately protect the government's interest in avoiding duplicative and wasteful litigation. In response to that concern, this measure, H.R. 2329, provides greater guidance to the courts as to whether a later filed action should be stayed. Specifically, the measure authorizes the court in exceptional circumstances to terminate or modify the stay if necessary to preserve material evidence or to prevent irreparable prejudice. In addition, the bill, at the suggestion of the Justice Department, mandates that the United States Court of Appeal for the Federal Circuit Court has jurisdiction over an appeal from an interlocutory order terminating or modifying a stay to preserve material evidence or to prevent irreparable prejudice. It's my understanding that the bill as revised now largely addresses the Justice Department's principal concerns. And I commend my chairman and colleagues on both sides of the aisle for their cooperative efforts to respond to these concerns. And so I fully support H.R. 2329 and urge that my colleagues do so as well. And I thank you and yield back my time.
Thank you, Mr. Conyers, and I'd now like to recognize the Vice Chairman of the Subcommittee on the Constitution and Civil Justice and the chief sponsor of this bill, the gentleman from Florida, Mr. DeSantis, for his opening statement.
Thank you, Mr. Chairman. Under current law, military, federal, and civilian employees, private property owners, U.S. taxpayers, Indian tribes, and others face unnecessary procedural barriers when attempting to defend their rights against the U.S. government in court. In many cases, federal law requires a plaintiff with a monetary and non-monetary claim against the U.S. arising out of a single incident to file two separate cases, one in the district court and one in the claims court. However, federal law also prevents a plaintiff from simultaneously filing a lawsuit in both district court and federal claims court arising from the same incident. This represents a procedural catch-22, which prevents many plaintiffs from obtaining complete or even partial redress for their injuries. For example, when the federal government infringes on an individual's private property rights, the property owner is currently forced to select between two potentially valid claims: to seek monetary compensation or to challenge the validity of the government's action. Because there's a 6-year statute of limitations on pursuing claims in these kinds of cases, and because these types of cases often move slowly, a bar against filing monetary and non-monetary claims at the same time can often close one legal avenue or the other to a plaintiff simply because there isn't time within that 6-year window to pursue both cases back to back. Plaintiffs are forced into choices they shouldn't have to make. As one federal court observed, the statute essentially says to plaintiffs, if you want your job back, you must forgo your back pay, and conversely, if you want your back pay, you cannot have your job back. This has the effect of insulating government from the type of accountability that President Lincoln thought essential when he said that the government must be able to render justice against itself in favor of citizens, and that was equally important as rendering justice between private parties. 28 U.S.C. Section 1500 is a statute from the 19th century designed to handle issues that are dissimilar to issues that we face in our time. And although federal courts have sought to place a judicial gloss on Section 1500 that would lower the hurdles faced by plaintiffs, the U.S. Supreme Court rejected this approach, insisting that the statute be applied as written. I believe the Supreme Court correctly applied the statute as written. In fact, I wish they would apply statutes as written more often. It is the job of Congress, not the courts, to fix provisions of law that do not serve the public interest. My bill, Ensuring Access to Justice for Claims Against the United States Act, will do just that by allowing plaintiffs to simultaneously pursue both monetary and non-monetary relief when the government infringes on their constitutional, statutory, or contractual rights, and will level the playing field between plaintiffs and the federal government. I hope this bill will receive the support of the committee. Thank you, Mr. Chairman, and I yield back.
Thank you, Mr. DeSantis, and now I'd like to recognize the lead Democrat co-sponsor of the bill, Mr. Cicilline of Rhode Island, for his opening statement.
Thank you, Mr. Chairman. I am proud to rise in support of Ensuring Access to Justice for Claims Against the United States Act. This legislation amends Section 1500 of Title 28 of the U.S. Code, which prohibits the Court of Federal Claims from exercising jurisdiction over a claim if the plaintiff has the same claim pending in another federal court. It would allow the CFC to issue a presumptive temporary stay on a later filed action instead of requiring courts to dismiss later filed actions, and removes an obstacle to judicial review for valid claims. It's a common-sense reform proposal that enjoys the support of both the Administrative Conference of the United States and the American Bar Association. I'm proud to support this legislation as a co-sponsor, and would like to thank my colleague and the author of this bill, Congressman Ron DeSantis, for his leadership and for demonstrating that we can work together and provide bipartisan solutions that will help everyday Americans access justice. I would also like to acknowledge the good faith efforts on both sides of the aisle to put the interests of the American people first and push forward this critical reform. And while I recognize there will sometimes be disagreements on how to address major policy issues, our nation faces serious challenges that can only be resolved through sustained dialogue and cooperation. It's my hope that we can continue to work in this bipartisan and cooperative way to meet the challenges of the future. I urge my colleagues to join me in supporting this legislation. I yield back the remainder of my time.
Chair thanks the gentleman. Are there any amendments to H.R. 2329? A reporting quorum being present, the question is on the motion to report the bill H.R. 2329 favorably to the House. Those in favor say aye.
Aye.
Those opposed, no. The ayes have it. The bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 2604 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2604, to improve and reauthorize provisions relating to the application of the antitrust laws to the award of need-based educational aid.
Without objection, the bill is considered as read and open for amendment at any point, and I will begin by recognizing myself for an opening statement. H.R. 2604, the Need-Based Educational Aid Act of 2015, continues an antitrust exemption that is set to expire on September 30, 2015. The exemption allows participating colleges and universities to collaborate on a set of criteria to determine applicants' needs for private financial aid. To be clear, this exemption does not apply to federal financial aid, only to aid directly provided by the participating colleges and universities. The Antitrust Modernization Commission generally cautioned against antitrust exemptions and recommended that Congress closely examine any proposed antitrust immunities. The antitrust exemption continued by H.R. 2604 has been in place since 1992. Over the past 23 years, Congress has extended the antitrust exemption on 3 separate occasions, each time with broad bipartisan support. Additionally, the Government Accountability Office conducted a study to determine whether the exemption adversely impacted the affordability of college and concluded that it did not. While H.R. 2604 continues the existing antitrust exemption, it also narrows it in recognition of the fact that one of the practices allowed by that exemption has not been utilized by participating colleges and universities. Accordingly, the legislation narrows the scope of the antitrust exemption to those activities that colleges and universities truly need and use. Given the lengthy legislative record, the narrowed scope of the exemption, the GAO study on the effects of the bill, and the 7-year sunset included in the bill, I believe that H.R. 2604 proposes a safe extension of a reasonable and worthwhile antitrust exemption. I thank former Chairman Smith for introducing this legislation, and I urge all of my colleagues to support the bill. I now recognize the ranking member of the committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. H.R. 2604, the Need-Based Educational Aid Act of this year, would extend for 7 years an exemption to the federal antitrust laws that permits certain colleges and universities to, among other things, agree to award financial aid based on need. I support this bill for a number of reasons. To begin with, I believe there's a strong policy reason to extend the current exemption. As a general principle, I'm deeply skeptical of antitrust exemptions and will only support them when they are strong policy reasons to do so. For example, I've long opposed the antitrust exemption for health insurance companies under the McCarran-Ferguson Act and have introduced legislation for several Congresses to repeal this exemption. My legislation, H.R. 99, would ensure greater competition among health insurance companies by repealing their exemption for the most egregious anti-competitive behavior, like price fixing and bid rigging. Nonetheless, there are limited circumstances where strong policy justifications support narrow exemptions to the antitrust laws. For example, labor unions enjoy a limited exemption so they can organize, strike, and collectively bargain. These exemptions are necessary to allow unions to form in the first place and to effectively carry out their critical mission of protecting workers' rights. 2604's limited antitrust exemption for colleges and universities, like the ones for unions, also serves an important policy goal. Congress first enacted this exemption to assure that financial aid is made available to the broadest number of students solely on the basis of demonstrated financial need. Colleges and universities are concerned that without this exemption, they'd be required to compete for the very top students through the use of financial aid awards. This situation could result in a system in which only a few receive an excess of the available aid, while the rest of the applicant pool receives less or more likely none at all. Ultimately, such a system could undermine the principles of need-based aid and need-blind admissions. Extending this exemption also makes sense because we know that it will not have anti-competitive consequences. In 1992, Congress first passed a temporary antitrust exemption similar to the one in H.R. 2604 and has since extended it again in 1994, 1997, 2001, and again in 2008. During these more than 20 years, we've been able to witness and evaluate the exemption and have found no evidence of any adverse impact. Finally, I support the legislation because it further narrows the existing exemption to ensure that it best meets its public policy goal. In addition to allowing schools to agree on need-based financial aid awards, use common principles for analyzing financial need, and use a common application for exemption currently allows schools to exchange a student's financial information through a third party. The bill eliminates this latter provision based on technical feedback and based on the fact that schools have not relied on that provision. And in closing, I appreciate the thoughtfulness with which H.R. 2604 has been drafted. It will continue to protect need-based aid and need-blind admissions and at the same time preserve the opportunity for all students to attend the school of their choice based solely on their talents and drive. And for those reasons, I urge my colleagues to support this bipartisan legislation. I thank the chair and yield back the balance of any time.
Thank you, Mr. Conyers. I'd like to now recognize the former chairman of the committee and the chief sponsor of the bill, the gentleman from Texas, Mr. Smith, for his opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I also appreciate your willingness to bring this bill to markup today, and this is H.R. 2604, the Need-Based Educational Act. And I also want to thank the ranking member, Mr. Conyers, for his support as well. Mr. Chairman, the bill extends the current antitrust exemptions that are set to expire on September 30th for another 7 years. The Need-Based Educational Aid Act allows a limited number of private colleges and universities that admit students on a need-blind basis to award financial aid from the school's own funds based entirely on students' demonstrated financial need. H.R. 2604 authorizes these institutions of higher education to use common principles to assess students' financial need, and it allows the schools to use a common financial aid application form. It also permits multiple schools that have accepted the same student to award the same assistance. This ensures that the student selects the college that is the best fit rather than the school that offered the most financial aid. This issue has long been of interest to me, having worked on the 3 previous extensions. Common treatment of this narrow category of educational aid makes sense. A Government Accountability Office study that resulted from a previous extension found that there has been no abuse of the antitrust exemption. It also determined that there has been no increase in the cost of tuition as a result of the exemption. The Need-Based Educational Aid Act helps ensure that financial aid is available to the broadest number of students solely on the basis of demonstrated need. Students who otherwise qualify should not be denied the opportunity to access higher education due to limited financial means. H.R. 2604 protects this need-based aid and need-blind admissions. Finally, let me thank my colleague from Georgia and the co-author of this bill, Mr. Johnson, for his efforts to advance this legislation. I urge my colleagues to support the Need-Based Educational Aid Act, and I yield back the balance of my time. Thank you again, Mr. Chairman.
Thank you, Mr. Smith, and it's now my pleasure to recognize the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, the gentleman from Georgia, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman. H.R. 2604, the Need-Based Educational Act, or AID Act, of 2015 would extend an exemption to the federal antitrust laws that permit some of our nation's most prestigious colleges and universities to agree to admit students on a need-blind basis and award financial aid to students with the most demonstrated need. I am pleased to serve as the lead Democratic co-sponsor of this bipartisan legislation. I thank my colleague, Congressman Lamar Smith, for his steadfast leadership on this bill since the 105th Congress and also during this particular Congress. H.R. 2604 allows colleges and universities that admit students on a need-blind basis to collaborate on the formula they use to determine how much families can pay for college. This exemption was first enacted in 1994. And since then, Congress has reauthorized it 3 times without opposition, most recently in 2008. In addition to allowing collaboration on a common formula for calculating ability to pay for college, the exemption also allows academic institutions to agree to award aid only on the basis of financial need. In other words, this exemption ensures that the most qualified students may attend some of our nation's most prestigious schools regardless of family income. This is especially important for low-income students who should not be forced to choose between the academic institutions on the basis of financial aid alone. While I think we could do more to empower students through better funding of higher education, this legislation is critical to preserving a level playing field for students at these institutions through a need-blind admissions process. The 568 Presidents Group, which is a coalition of 23 prestigious colleges and universities that support need-based financial aid, strongly supports this bill, stating in a letter to the committee that it allows these institutions to maximize the allocation of financial aid to, quote, ensure that those funds are targeted to the benefit or to benefit the students with the greatest financial need, and to reduce or, in some cases, eliminate debt loads on graduation, end quote. Similarly, the presidents of Duke and Cornell have written in support of H.R. 2604 that it, quote, makes a real difference for our students, end quote, and is essential to developing the, quote, best practices to calculate institutional aid awards, end quote. I ask unanimous consent that these letters be made a part of the record. And in closing, I thank the chair for holding today's markup, and I encourage my colleagues to support H.R. 2604, and with that, I yield back.
Chair, thanks, gentlemen. Without objection, the document will be made a part of the record. Are there any amendments to H.R. 2604?
Great job, sir. Thank you.
A reporting quorum being present, the question
Chairman,
is,
Mr.
for
Chairman,
what purpose the gentlewoman from Texas seek recognition?
I'd like to strike the last word.
Gentlewoman is recognized for 5 minutes.
I know that this legislation has drawn enormous bipartisan support, Mr. Chairman. I do not have an amendment, but I would like to indicate as a representative of a city with a multiple numbers of colleges and universities, and for fear of offending any of them, I hesitate to call names, but I will mention the University of Houston, Texas Southern University, Rice University, Houston Baptist, and then a huge number of community colleges in which I engage in. This is a very important initiative for those colleges. As Mr. Johnson has indicated, it is the idea of combining resources or understanding resources and how they can best distribute them to our students. We know that the higher education, whether it is community college or four-year colleges, as the doors of opportunity to our students. Just 2 days ago in my district, I had a town hall meeting on the Houston Community College and a more effective way of it serving its constituents and my community. And therefore, this legislation to provide for an open opportunity to collaborate on need basis for admission and as well for resources is vital to the future of America. And I would like to add my support to HR 2604, Need-Based Educational Aid Act of 2015. And I'd like to get this bill signed by the President, because I think this is another step toward the doors of opportunity that the nation needs, and it is another step toward competitiveness, which we face every day to make our population more competitive. With that, I yield back my time.
Are there any further members seeking recognition on H.R. 2604? Reporting quorum being present, the question is on the motion to report the bill H.R. 2604 favorably to the House. Those in favor will say aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. This completes the business for today. I thank all the members for their participation. The meeting is adjourned.
Amazing record.